Hello and welcome to this defence on automatism. So this defence is another capacity defence. The other capacity defences we look at in A-level law are of course intoxication and insanity. There are videos on those too. You can go ahead and watch them, but this is just going to focus on automatism. The aims of this then, of course, as ever, are to develop your understanding of sane automatism, which is of course what we're looking at in this video, but of course the difference between that and insane automatism or insanity. Now at the conclusion of this video, you'll be able to define automatism, and give examples of conditions giving rise to it, distinguish between sane and insane automatism, or automatism and insanity as we know, and of course you'll be able to apply those definitions to problem questions. So first off, we're going to consider when we use defences in problem questions. So in all of the problem questions, we're going to be able to have to use some defences. So in criminal law for A level, you have for AQA level, for example, you've got the offences of the fatal offences, the non-fatal offences. We've got theft and robbery. Now what we've got is this can be applicable to almost any offence we look at. So we need to make sure we're aware that it could come up at any point. So once we're analysing that problem question, we look carefully for them and then consider the link between those partial defences as well. So the thing like diminished responsibility and so on. Now, although you're not required to go into them in much detail, as the offences, you need to apply them to the scenario. And you won't get a good grade if you don't consider any defences. You're not going to hit all the indicative content guides. So really we need to start with what automatism is. So it arises when the body acts for itself without control of the mind. Now the word automaton is a robot. So you might consider you're acting in a robotic state. That's what automatism is. Now this might apply to, for example, a sudden muscular spasm or fit, a sudden temporary illness, sleepwalking, although that could also be insanity as we've seen, a hypnotic trance, or an accident causing concussion, the effects of anaesthetic administered for proper medical reasons, or indeed the intervention of a non-human agency such as a swarm of angry bees which makes the person act in a way that they've not controlled. So a definition of automatism comes from the Attorney General and Bratti from 1963, and it is an act done by the muscles without any control of the mind, such as a spasm, reflex action or a convulsion, or an act done by a person which is not conscious of what he's doing, such as an act done while suffering from concussion or while sleepwalking. So of course what we've got then, automatism. Now there are two types of automatism. We've got insane automatism and non-insane automatism. Now for ease of reference, we're going to call insane automatism in the defense of insanity, and that is dealt with in a separate video. For this we're going to focus on non-insane automatism. So the effect of this defense then, well, in the rare situations that automatism can be proved, it succeeds as a defense. Now it's going to be a total defense resulting in a not guilty verdict. Now the rationale for this is that the defendant's conduct is not voluntary and didn't have the mens rea, so therefore should be held responsible. So the key elements of automatism then are these three. So first of all, the act must have been involuntary, so the thing the defendant did must have been involuntary. Secondly, this must be caused by an external factor. And the external factor, we're going to consider what that might be. And of course then, it must not be self-induced. So for example, this external factor must not be put into the body on purpose, for example, or in a way in which it's likely to make sure the defendant acts in that particular way. So we're going to deal with the first element. The act must have been involuntary. So we've dealt with this case already, Bratti and the Attorney General from 1963. Now in this case the defendant was convicted of murdering an 18-year-old girl, and of course the definition of automatism came from this idea of describing any act done by the muscles without control of the mind is automatism. Now in this case it blacked out, so it was considered to be automatism. Now in the Attorney General's reference number 2 of 1992, it was said that to use this defence successfully, there must be a complete absence of self-control. Now, if there's any evidence of control, this will negate or undermine this defence. So in this case, the driver of a heavy goods lorry had crashed into a stationary vehicle on the hard shoulder of a motorway, killing 2 people standing nearby. But it was acquitted of causing death by reckless driving after the recorder had left sane automatism to the jury. Now, the expert evidence showed that while he'd not fallen asleep at the wheel, he'd been put into a trance-like state by the repetitive vision of the long, flat road, which reduced but did not eliminate awareness of what he was doing. So the court of appeal, however, following the decision in Broom Perkins, confirmed that driving without awareness is incapable of founding a defence of automatism unless there is total destruction of voluntary control on the defendant's part, and impaired or reduced control is not enough. So this really hammers home that point. It has to be a total loss of voluntary control. Now in Charleston, a father hit his son on the head with a hammer and threw him into a river. Now the defendant suffered from a cerebral tumour, and the jury acquitted him as his mind was not in control of his limbs. So again, here we've got a total loss of control. This will support the defence. In Woolley, sneezing was accepted as an involuntary act, and the defence of automatism was allowed. Now, the defendant admitted he was driving very close to the car in front of a queue of slow-moving traffic on the M62 near Manchester. Now, he alleged that suddenly he had a sneezing attack and lost control of his HGV wagon. He crashed into the car ahead, and this caused a domino effect involving 7 other vehicles. Now, the court decided that an attack of sneezing could be a type of involuntary act that came under the defence of automatism, and he was not guilty. So again, that total loss of control, you've got the idea of sneezing, that would suffice. In Hill and Baxter, a classic case. So a driver here was behind the wheel when his car collided with another. At his trial on the charge of dangerous driving, he claimed he'd been overcome by an unknown illness and been unconscious. Now the magistrates acquitted him on the basis of automatism, but the divisional court allowed the prosecutor's appeal. Now a claim of sudden illness or concussion must be supported by some credible evidence, they said, but usually going beyond the defendant's mere assertion. But the burden of proof thereafter is on the prosecution to show the act was a voluntary one. So you'll come across this case when we talk about actus reus, but in this particular case then this idea of a sudden illness got to be supported by some medical evidence. Now in the Crown and T, the defendant in this case pleaded automatism to charges of robbery and assault occasioning ABH. Now she'd been raped 3 days earlier, which caused PTSD, and that was supported by a psychiatrist. Now she entered in what we would call a dissociative state, and the judge allowed automatism to be left to the jury and suggested that such an incident could have an appalling effect on any young woman, however well balanced normally. So we've seen a number of different cases there which illustrate the ways in which the act can be considered involuntary, from PTSD in a dissociative state right through to sneezing. What this must be though is the second element is that it must be caused by an external factor. Now if you've seen the insanity video before this, or this is a recap, then you'll know that, for example, we're going to contrast the idea of insulin versus diabetes from an internal to an external cause. But we're going to look at the ways in which it could be an external factor, or considered to be an external factor. So the court will not normally accept a defence of automatism then without some medical evidence to support it, and even then are understandably still quite cautious. So the cause has got to be external. If it's internal, the defence of insanity could be raised instead. So some examples of external causes, as we mentioned earlier on, are things like a sudden muscular spasm or fit, being attacked by a swarm of bees. This was the hypothetical example from Hill and Baxter. The effects of anaesthetic, an accident which causes concussion, a hypnotic trance, or a sudden temporary illness, for example. And once again, we're going to come to the case law to illustrate the points. What is an external cause? Well, the appeal court in Hill and Baxter said the driver needed medical evidence of this sudden illness. But what he did though was drive through a halt sign without stopping, and he collided with another car. Now he was charged with dangerous driving but acquitted by the magistrate, who accepted that he'd not known anything or remembered nothing from some distance before reaching this sign. Now the divisional court allowed the prosecution's appeal and put the case back to the magistrate with a direction to convict, as there was no evidence to support a defence of automatism. Now in terms of this external cause then, we need to be aware of the judgment from K and Butterworth, which was used as an authority, in which a person should not be made liable at the criminal law who, through no fault of his own, becomes unconscious while driving, as for example a person who had been struck by a stone or overcome by sudden illness, or when the car had been put temporarily out of his control owing to being attacked by a swarm of bees. So this of course is obiter dicta, but allows an authority, this is a persuasive authority as we know, a persuasive precedent, which could be used in future cases. So any of those would be then considered an external cause. Now in Sandy Smith, in the Crown of Sandy Smith, the defendant claimed threats she made to the victim were due to PMT or premenstrual tension, but the courts refused to accept it as there was no medical evidence to support. And in any case, this is not an external factor. Now we're going to look now at some cases with the successful uses of the defense of automatism, and therefore the second element would be satisfied. So in Bilton, a man accused of rape was acquitted as he was sleepwalking. Now we've seen sleepwalking in insanity as well, and it was considered an internal factor or internal disease, but curiously we're going to see a number of times in which it's also been considered automatism, because it arguably could be an external factor. So I guess the justification there is that we've got something affecting the sleep, and that's the condition, so of course it would be external as well. Now in Antoniuk, we've got a defendant who stabbed her lover in a robot-like trance after he had raped her. She was acquitted on the basis of automatism. So this robot-like trance, I mean, that's almost exactly the definition, isn't it, of automatism, or being an automaton. And then Quick, as we mentioned earlier on, is going to contrast it with Hennessy, because in Hennessy it was an internal cause, the actual disease of diabetes, and so it was insanity. But here we've got a diabetic who was suffering from low blood sugar. Now the jury should have been allowed to consider this, but indeed he had to take an insulin, so it was an external factor, which means it could use the defense of automatism. And so once we've established those two key elements, so the act must have been involuntary, it must be caused by an external factor, we need to make sure that it was not self-induced or caused by the defendant in any way. So self-induced automatism then is when the defendant takes a substance and knows it's likely to bring an automatic state about. So for example, if a diabetic takes insulin and doesn't eat, then the insulin, which is designed to counterbalance eating, will have its own effect. And this is a known effect. Now, a defense works differently depending on whether the offense itself is a specific intent offense or a basic intent offense. Now, for reference, specific intent offenses you can only do with intention. Basic intent offenses you can do recklessly also. But there does need to be some voluntary conduct. Now, if the automatic state results from an appropriate action, but with unanticipated consequences, then automatism would be a defense. So, for example, if you prescribed a prescription drug and you had an adverse reaction. Now, if the automatic state results from some form of a willing omission, for example, the defendant or with diabetes, then it will be a defense to a specific intent offense, but not to a basic intent offense, because of course, becoming intoxicated or taking some form of medicine without that counterbalance, for example, as we say with diabetics and insulin, then the course of conduct in not taking the thing is reckless. So that would satisfy the reckless element for the mens rea of basic intent offences. Now, if you've come to this after seeing the intoxication video, you will know also that the same applies in intoxication. So with reference to specifically intoxication in automatism, this can undermine the defence where voluntary intoxication has taken place. So in Lippmann, we know the defendant took LSD and had a trip. Now he killed his girlfriend thinking he was fighting snakes in the centre of the earth. Now there was no doubt he was in an automatic state, but indeed it was brought about by intoxication, so this would be considered to be self-induced, and that defence would need to be used instead. Automatism was not allowed. With Majeski, the defendant attacked police officers and was charged with basic intent offences, but he was intoxicated, so again he could not use the defence of automatism. Now, also to allow intoxication as a defence would leave the citizen legally unprotected from unprovoked violence where this was the consequence of drink or drugs. Now, a quick note then, of course, in your problem questions, if you've got intoxication and automatism, you could suggest why one is not applicable and the other is. You could just go for intoxication if that's more applicable. You make that decision, and there's a skill you'll learn as you more practice this with exam questions. Now, in Coley, the defendant attacked neighbours after using cannabis, and he had a psychotic episode, but it was brought about by the cannabis, an external cause. Now, when automatism was raised, this defence could not be used because he was intoxicated and he had some control of what he was doing. And in McGee, the defendant suffered from tinnitus, which is a condition of the inner ear, which is like a loud buzzing or ringing in the ear. So he took alcohol and temazepam to help him sleep. Now, he was charged with section 47 to section 18 offences because against shopkeepers because he claimed to have no recollection, but his defence failed because even if he was in an automatic state, the condition was brought on by alcohol and the use of temazepam. So it was self-induced. Now, in Bailey, the defendant was a diabetic who suffered from diabetes for 30 years. Now, he needed insulin to control his condition. Now, he became very upset when his girlfriend had ended their relationship and befriended another man. But Bailey visited this man to discuss the position, and after 10 minutes complained of feeling unwell and requested a drink of water and sugar. Now, before leaving, he asserted that he lost his glove, and as the other man bent to look for it, Bailey hit him over the head with the hammer which he brought with him. But the jury found him guilty of malicious wounding. Now, there was an element of control there, and they should have controlled his drugs. He had 30 years of being able to control it, so of course this was sort of self-induced by not controlling the condition. Now, in Hardy, again we've got diazepam here. The defendant set light to wardrobe about to consume some out-of-date Valium or diazepam tablets, which were prescribed to his partner. Now, he took the Valium tablets as he was feeling stressed, as his partner had asked him to leave their home. He was charged with arson at the trial, and he stated that he remembered nothing of starting the fire due to his intoxicated state, but accepted he must have started it as he was the only one in the room. Now, the trial judge directed the jury that as defendant had voluntarily consumed Valium, his intoxication could be no defence to the crime committed, and the defendant appealed. The appeal was allowed because, of course, in this case it was a drug, but with an unknown effect. So this was not self-induced. So Lord Justice Parker said in this case, it maybe will be the taking of sedative or soporific drug will in certain circumstances be no answer, for example in the case of reckless driving. But if the effect of a drug is merely soporific or sedative, the taking of it, even in some excessive quantity, cannot in the ordinary way raise a conclusive presumption against the admitted proof of intoxication for the purpose of disproving mens rea in ordinary crimes, such as would be the case with alcoholic intoxication or incapacity or automatism resulting from the self-administration of dangerous drugs. Now, to put simply, basically, if the defendant is not reckless in becoming intoxicated due to prescription drugs, they can still plead automatism, or even just total lack of mens rea. So, of course, what we got here is that the act must have been involuntary, it must be caused by an external factor, and it must not be self-induced. Now, this is normally to do with taking some form of drugs or intoxicant, but remember, it's different if they take a soporific or sedative drug and they're not reckless in becoming intoxicated. So they're the three elements, fairly simple. We use cases to support our findings and our arguments, and thank you for watching.